or legal services. So on some level, this is a subset of confidential information. But it is dependent upon the work that an attorney does. And so here we're talking about discovery practice as the remedial framework to deal with the assertion of a privilege. So this breaks down, if we're talking about the elements of the attorney-client privilege, you have several things. You have communication between lawyer and client. You have privileged persons. Communication and confidence. And I'll just put for the purpose of seeking legal assistance. So the book goes through each of these components and discusses the definition of them. And so you see, starting on page 158, what the book emphasizes is that you have to be very careful in this context. So you have the rules of confidences that we talked about, and we have privileges as well. But we want that privilege to attach, and so we want to be very careful about how we conduct our business. So if you have an interpreter in the room that works for you, you interview the client, and then sometime later opposing counsel says you waived the privilege because you had an interpreter in the room. How would you argue? How would you deal with that argument? Opposing counsel. Opposing counsel said, I deserve to hear everything that you said to this client because there was a third person there, the interpreter. Therefore, you waived the privilege. I'm going to go to the court and get them to compel you to give me this information. Go ahead.
The interpreter was there because they were needed to facilitate communication between the lawyer and the client.
Good.
So in that context, they were the go-between to facilitate communication.
Okay, good. What if there's a guy that just hangs around the office and he's thinking about being a lawyer, so he just wants to observe and take notes on different things. He wants to be an apprentice one day and then learn how to be a lawyer, then maybe go to law school. So he comes to some of your interviews and takes notes. Opposing counsel finds out about that. Does the same type of motion. Motion to compel discovery of these statements because you waived the attorney-client privilege. What about that? Yeah.
I did that over the summer in my job, and they made me sign like a thing that basically got me like the same rules as the lawyers.
That's good. Why do you think they did that?
I guess because otherwise maybe it would be, maybe we don't really do anything like litigation, but I mean, it could violate the privilege.
Oh yeah, it doesn't matter. It could be a transaction or whatever. Deposition, that's good. And so they want to make sure that you're just not an extra person around, and therefore you waive the privilege. And so that's why they had you sign it. The lawyers should always clarify the role of third parties to avoid waiver. That's on page 159. So what about this motion? Underlying facts are not privileged. So this might be a distinction you have to make in discovery practice. So opposing counsel is trying to get all of your information, and you say, no, this is attorney-client privilege. This is the communication between the lawyer and client. All the privileged persons are there, no waiver. Communication in confidence, not so much related to the representation, but within the context of this representation, not as broad as confidence, for the purpose of seeking legal assistance. But then opposing counsel comes back and says, well, all that's fine and good, but I'm not really talking about privilege. I'm talking about the underlying facts. How do you make a distinction between those two? And so what I'm getting at is there could be a scenario where you get at this information another way apart from attorney-client privilege. But what is this distinction between underlying facts and protected information under attorney-client privilege? Like that example 161, how do you explain that? Underlying facts are not privileged. So how do you segment what the client tells you that is protected and what has to be revealed? So what's the difference between the client telling you, yeah, I really was driving carelessly. I probably took too many prescription pills and just got the prescription, didn't read it carefully, and I probably did do some of that. So that's one. And then what if opposing counsel says, I want you to tell us everything. How many pills did you take? Could you say, instruct the client not to, this is a deposition, instruct the client not to answer? You don't have to tell them how many pills, that's attorney-client privilege. So what's the difference? Yes, go ahead.
Just the fact, like what time did you take it, how many did you take, they have to do it. I don't think they're required to speculate that it was too much or that it might have caused them to be fired.
Okay, that's good. So what's the difference between those two?
One is just a fact and one is more of a theory or opinion or...
Theory and opinion that may have been gone over by the attorney-client in confidence, seeking legal advice. So you can't be compelled to testify about what the client told the lawyer seeking those legal services. But the underlying facts of this particular transaction or the accident are not privileged. Everyone is able to get that type of information. Another thing is that the privilege is waived if the client reveals the privileged information to a non-privileged person. So that could be a very dangerous now, particularly with social media. So I went to my lawyer's office today and he told me how we're going to win this case. He's going to win $100,000. Here's how, and then have your friends vote on that. This is the best strategy, like or not like. And so you would probably waive that because there's so many non-privileged. You've expanded the group in this conversation. Whenever that occurs, there is danger of waiver. No privilege attaches if the client consults a lawyer for assistance in committing a crime or fraud. So that just builds upon what we were talking about with Lisa's pieces in Rule 1.6b2 and b3. Your services cannot be used in the furtherance of a crime or fraud. And attorney-client privilege carries this forward with the crime fraud exception on page 165. So there's a clear distinction, remember, between past crimes and that you're advising the client on and advising and assisting in the commission of the crime. If you're advising and assisting in the commission of a crime, no privilege. Another thing on page 166. Now notice this. This is interesting. There's a case you don't remember. This is a long time ago. But anyway, during the Clinton administration, Vince Foster, who was a high-level Justice Department and advisor to the Clintons, was found dead in Rock Creek Park in D.C., committed suicide, just shortly after getting to D.C. And there was an investigation, and it unraveled in the Ken Starr investigation. But anyway, there was litigation. Ken Starr wanted to get notes that Vince Foster had taken and talked to his lawyers about. And there's a case from 1998, Swerdler in Berlin versus United States, that says the privilege survives the death of the client. So notice this even says on 166, the attorney-client privilege remains in force even if revelation will prevent the wrongful incarceration or execution of an innocent person. It remains in effect after the client dies. Now, how much sense does that make to you, that it lasts that long? And you have a choice between doing justice and doing the right thing or preserving the reputational interest of someone who is no longer here. So if we say that the right of privilege belongs to the client and we can't waive it unless we get some express authority, and now the client is dead, why can't the lawyer exercise discretion and reveal this information? And that's the question that we have on page 167. How would you approach that? Secret confession on page 167. So notice there's a notion of justice, doing what's right, revealing, and then what the rule says. And you can even look at, there's another rule that sort of goes along with this. If you look at even comment 20. Comment 20 to rule 1.6 says the same thing that it says in our book, that this duty not to reveal or preserve confidence is indefinite. It says something like this. Now, so this is sort of underscoring something that we're going to do in some subsequent chapters when we talk about former clients. So keep in mind, just because you stop representing a client does not mean that your duties cease. And we're going to see this over and over again when we talk about former clients who do these conflict rules. Notice this, the duty of confidentiality continues after the lawyer-client relationship has terminated. So, you know, the difficult thing about this rule is, whether we're talking about attorney-client privilege or confidence, is it just says it goes on and on. It doesn't give us any measuring stick about when does it end. And it doesn't seem like it ever ends. So look on page 167. We represent the client, James Chester, who is involved in a murder. And the client Chester, you see on page 168, says that he did it alone. He killed the victims, and someone who is incarcerated, Parnett, is not involved. See on top of page 168. He asked us what he should do. We're his attorneys. And we advised him to reveal. If we advise him to reveal that he committed the murder, the prosecutor may refuse the plea agreement and seek the death penalty. If you alone did it, we're going to hold you responsible. And so you have a number of scenarios there on page 168. May we reveal to the prosecutor before Parnett is sentenced to life in prison that Chester has confessed, our client has confessed to the killing and exonerated Parnett. Can we reveal the client's confession to us? What do you think? So a number of ways to look at this. Justice means something, and even if it means throwing our client overboard, there's a higher and nobler purpose. So we reveal whether our client wants to or not. Can we do that? Put justice for Parnett ahead of everything else. In fact, 1.6b1 allows us to reveal because jail is so hazardous that the threat is imminent, and that gives us discretionary power to reveal, and we should reveal. And so even though the rule requires us to protect the confidences of the client, there is some harm here that we could identify that would allow us to exercise our discretion under 1.6. What about that? Would you reveal? So if Parnett goes to prison, he could get stabbed, violence, any number of things. So should we reveal to the prosecutor? Yes.
Morally, I would say yes, but in terms of legal ethics, we're still bound.
Okay.
Which is a horrid situation
Indeed.
because that has been including opposition because
Yeah.
your duty to client also your duties not to the court.
That's good. That's good. And so this is all about assessing risk. That's good. That's good. Now let me ask this. So, what about my 1.6b1 argument? Can I really push that and say reveal?
That's really stretching it. Although I do agree that business of course happens, but it's still a stretch that I'm not sure like, most people find.
That's true. And you know, it's too speculative, I guess. And even though the rule isn't great in giving us an example, it probably needs something more imminent than this can occur in a particular location. So that's go ahead.
No, I was gonna say he can get stabbed anyway.
Yeah. Okay. Yeah. That's right. Anyway. Yeah. So this class is hard. Is it okay? That's good. But that's right. So what you're underscoring is where's the imminence? It can happen anywhere. And if you're going to exercise this discretion, you probably need to turn it back. Yeah.
I thought if you had information that was exonerate someone, you had to disclose it.
Say that.
Like if you have information that was exonerate someone, you don't have to disclose it.
Why?
Why?
Yeah.
But then
Oh, it's the right.
also accused.
Yeah, it's the right thing to do. But what about this? Our duty to preserve confidences. You're not gonna like this. And then on page 166, notice this. Traditionally, the attorney-client privilege remains in force even if revelation would prevent wrongful incarceration or execution of an innocent person, and it remains in effect even after the client dies. That's bad. So don't. So now in real life, what would you? Ms. Harper just said the rule, and you're reacting to that rule by saying, "Well, that's not right." So what would you do in real life? Oh yeah, yeah.
Honestly,
Let's go.
I probably like put an anonymous tip because like I'm not gonna let somebody die.
it's a risk, and so this is to show you that it's not a perfect world, and you might have to make some. So we know what the rule. We share this well. That's what the rule said. But then you're thinking about justice. You know someone is innocent, and then question 2 sort of makes that point. Does your analysis change if someone is sentenced to death row? Same thing. It's not really absolute. So even if we have this rule under 1.6b1 that would excuse us from the duty of confidentiality, there's no life-saving exception to the rule that would allow us to fail to honor the absolute attorney-client privilege, and that's bad. And we can't really exercise this greater discretion to prevent death. Go ahead.
That makes no logical sense, because that severely puts attorneys at odds with
Sure.
what they're supposed to do.
Indeed. So what should we do then?
Honestly, if it were me, I would take the risk and I would do it.
Mm-hmm.
What if, that's just for me personally, because morally, that's not something I just stand by my happen, especially if it were a death penalty case, and I knew they were about to make it.
Yeah. So notice, this is the tension you're identifying in this discretion. A lawyer's decision not to disclose as permitted does not violate this rule. So this might be burning in your conscience. I know this, I can reveal, but it would be a risk because it's really prohibited by the rule. Comment 20, as I said, the duty of confidentiality continues after the lawyer-client relationship is terminated. And notice what happens. Our client commits suicide, leaving no family behind. Can we now reveal? So he's dead, and because it doesn't make sense to protect his reputational interest. Cases say yes, it does make sense. So the client, even in death, maintains an interest in protecting reputation. So may you reveal? You're still concerned with justice. Now notice, to resolve this, notice number 4 on page 168. This is exactly what happened. So Ms. Hopper and Ms. Durbin say, this is horrible, we need to deal with this, and I know what the rule requires, no revelation, but I'm going to take the risk. Because discretion has to mean something if we're trying to save someone's life. So soon, we decide to reveal Chester's confession to Barnett's lawyer. Now notice, the one consequence is this. Now, if you do that, you have to be aware that now you're going to be a witness probably, or at least subpoenaed. So that's one thing to think about. And so he subpoenas you to testify at the hearing on the motion for the new trial. There's no one else but you really to talk about this. During the hearing, you're about to tell the judge your client Chester's confession. Now, this is what happened in the real case. The judge said, you better stop. I'm going to have to report you because we know, and he sort of gets confidences and attorney-client privilege mixed up. But anyway, for our purposes, you have to preserve the client's confidences. I'll be compelled to report you to the state bar for violating your former client's attorney-client privilege, which outlasts his death. So the reason I say it's more confidence is because attorney-client privileges, as we put up on the board, attaches to some type of proceeding, and we're trying to compel, and now we have the client who's dead. But anyway, we still have to protect this information. In the real case, for which this is based, this is what the judge warned. So, what do you think happened? You can comply with the judge's order and stop. You can testify anyway until he orders you to stop, or testify no matter what. And this was an actual attorney, a public defender. So all you're asking, divided loyalties, how can you let an innocent man stay in jail? The attorney revealed the client's confession after the client died. The judge did report it to the state bar. And what do you think happened? Think the lawyer got in any trouble or what? Well, you were like, reveal, this is wrong. What do you think? You think anything happened when you took this risk? No, good. So this was in Massachusetts. The bar complaint was eventually dismissed. I mean, when you go through, you get investigated, this and that. But ultimately, the bar complaint was dismissed. Now, I'm sorry, that was in North Carolina. The reason I say Massachusetts is this. To sort of address the concerns that you all say, well, someone's about to die, or we know that this person is innocent. One rule, and this sort of changes 1.6 to allow you to disclose. So it says, and that's how you mentioned officer of the court and all of that. There's a Massachusetts rule that says, makes it permissive. It says, a lawyer may reveal, and to the extent required by 3.3, officer of the court. 4.1b, cannot assist in fraudulent or criminal activity. Or 8.3, reporting misconduct, may reveal confidential information to prevent the wrongful execution or incarceration of another. So notice what that does. That's a nice permissive rule. It is 1.6b. This is just in another state. This is how they resolve the issue. So they give you the authority to reveal. A lawyer may reveal. And notice this, and to the extent required by 3.3, that's counter to the court. 4.1b, that's truthfulness in transactions with others. Or 8.3, that's reporting misconduct. May reveal confidential information to prevent wrongful execution or incarceration of another. So notice what that does, the last point. Notice what that does. It gives you more discretionary power under 1.6. Sort of removes this qualitative assessment of what imminence is, and says if someone is wrongfully on their way to execution or incarceration, the lawyer has the power to reveal. And so it plugs it into some mandatory obligations that the attorney has. Candor towards the tribunal, can't commit crime or fraud by having your services used, being truthful to third parties, and reporting misconduct. So that's just a way that Massachusetts has thought about dealing with this. When we come back, we'll finish up this chapter. We have one more problem, worldwide married, and then we will start chapter 5, lawyer-client relationship. Have a good afternoon.